Hello and welcome to the Institute of Economic Affairs podcast. I'm Callum Price. Today I'm joined by Matthew Lesh, who is our Public Policy Fellow and Country Manager at Freshwater Strategy. He's also the author of an old IEA briefing paper from a couple of years ago on the online safety, then Bill, now Act, and he's going to talk us through today everything online safety. Matt, welcome.
It's great to be back. In fact, I was looking back through the records, and my first appearance on the IEA podcast was in April 2019 when the government released the online harms white paper. None of them, some long-time listeners might remember Mr. Darren Grimes, the first host of this podcast, and Victoria Houston, former colleague here at the IEA and subsequent government advisor. So it's good to be back on the same podcast, talking about the same topic and having a look at what's actually happened.
And that's a good way to start us off, because effectively everything that you predicted has come to pass, hasn't it?
Yes, I have been viciously vindicated. Thank you very much. Podcast over. I think we can time to head back home now. That's all the listeners need to know. I mean, I'm not going to say absolutely everything we've said has come to pass yet. In fact, I'm not even all of the legislation has come into force just yet. But I think what we've seen in the last couple of weeks is very much kind of creepishly as expected in a few elements of the Act. I suppose the most prominent element of this has happened recently is the introduction of age gating, and there's been two forms of age gating. The first one is of online adult content, pornography, and that's got quite strict age gating. This is something we knew was originally the government wanted to do in 2017. They decided not to do it in 2019. They decided to do it again a few years later. Online Safety Act. That's the parts that's kind of pushing everyone to use VPNs, I suppose, if they want to access online content or have to identify themselves, raising a lot of privacy concerns. So that's kind of like one bucket. That's quite as expected. The other bucket of it, which is something that was, I suppose, not given quite as much attention during the Act's passing, but is more or less operating as Victoria and I wrote about in that IEA paper from 2022, which is that if you're going to put all these duties on the companies to hide content that could be harmful to children, then you're going to have to determine who is a child and who is an adult. And the Act also makes it quite clear that you're going to have to treat people as children by default. And if you have the net wide enough in terms of what you consider to be harmful to children, which is the way it's defined in the Act, there's been some commentary around, you basically now see all these posts on Twitter saying, this is not viewable in your region because we have to estimate your age or determine your age. And there's some commentary saying, well, that's a mistake, or something's kind of technically gone wrong here, and this material shouldn't be hidden. I think I've actually fundamentally disagree with that. The Act, by design, says that if something is psychologically potentially harmful to children, then the duty is on the companies, on the platforms, to hide that material until they determine that someone is an adult. That psychological harm can include really anything, I suppose. And what we're seeing at the moment is, in order to fulfill the duties under the Act, in order to not face the threat of quite large fines, which has implications if you fail to follow your duties, you're seeing a lot of genuine political content hidden, be it transcripts from the rape grooming gang trial, or at least one of them online, lots of content from the wars in Ukraine and Gaza, other material that you might consider to be genuine part of public debate, but could also be psychologically harmful to children and therefore must be hidden by default on these online platforms. And as all that is the kind of censorship you're now seeing, censorship and by default, treating everyone as a child by default.
So there's extremely concerning ramifications for free speech then. It is quite literally censoring political debate and public records and things that we would assume that although being painful and horrible are pretty necessary so that we sort of understand what's going on in the world, and we are.
Many pointed out the irony here that the government's currently talking about giving votes to 16 and 17-year-olds, whilst at the same time, whilst at the same time hiding from those same 16 and 17-year-olds any material that could be considered psychologically harmful, but perhaps would be relevant to their decisions about how to vote. Now, what X has done in particular is interesting in the sense that they haven't actually given you a way to verify your age yet. So it's become that they've really shown this to their users in quite a prominent way. I'm not sure if that's something intentional or if that's simply because their systems weren't ready to do the age estimation process, and therefore they took a more conservative approach to what they would allow users to see. I mean, over time, users' age will be estimated. It will be harder to find this material. You will have to log into Twitter to see this material. It's not going to be shown to you unless you log in, unless you prove your age. Now, for people who don't necessarily want to link their identity to their Twitter account, if you want a truly anonymous Twitter account, you might not necessarily feel secure and safe in verifying your age, even if perhaps they say that we know they're not going to store your a photo of your face, or we're not going to store a copy of your passport. You still might not want to do it for the fear of your own safety. So it is creating a permanent block on access to information, on access to what is, we have to absolutely clear here, is legal speech. This is legal speech, but the speech that under the Act would be considered harmful to children because of that definition within the Act of anything being psychologically harmful to children needing to be removed or hidden from your site by default unless you can prove you're not a child.
Which is a really interesting point, because through the development of the white paper and then the bill, and then you mentioned earlier how they dropped these ideas and they reintroduced them. But one of the things that classical liberals and other campaigners did win on was them dropping the legal but harmful definition from the speech.
Yeah.
But in effect, there's still many of those problems still there in practice.
Yeah, indeed. In the original version, online harms white paper, there was a list of, I think it said, harms with a less clear legal definition was a phrase it used, which is just a way of saying things that are legal, speech that's legal. There was this tension with the Act to clearly use, indeed, as you're saying, to hide from adults this kind of same category of content. So perhaps one of the few victories for free speech advocates or classical liberals in this debate was the fact that, at the very least, if you prove your age on these platforms, you will be able to see this content. You will be able to see, let's say, imagery from war that is violent, or descriptions of concerning criminal cases. If in an alternative world where we weren't successful in getting the legal but harmful material removed from the Act, you're right. Perhaps it would never be accessible. You wouldn't be able to really use these platforms in a meaningful way anymore. Or alternatively, you could say the platforms would have to take a much higher legal risk. Now, the other one, of course, of what's going on here is it's not just the largest platforms like X or Facebook or Instagram that are implicated by this law. It's a much wider variety and set. In fact, it's any platform that allows you to have discussions amongst each other. And what's happening at the moment is a lot of those, particularly the smallest platforms, is something else that we talked about quite a lot. Interesting enough, in the government's impact assessment, it said that this would never happen. Of course, it is literally already happening, which is you're seeing platforms pull out of the UK. You're seeing at the kind of the micro level, you're seeing web forums like the Hamster Society, a few hundred-person discussion forum for people who are just in hamsters. They've decided they can't operate in the UK because of all the regulatory burdens placed on the Act on them. They're just a tiny volunteer organisation. They basically one-man shop, and it's going to cost thousands, if not tens of thousands of pounds to comply, even as a small forum. But then you're going to see international platforms choose to disengage from the UK, to block users from the UK, and we've seen quite a bit of that as well. So if part of the government's aim was to, I suppose, and it has been part of the government's aim in order to increase competition in online platforms, this is certainly something that is contrary to that aim because of all the regulatory burdens. So the other element of this, of course, I would say, is that losing access to platforms that are not the biggest platforms, and that in itself having quite serious free speech implications as well. It means the British version of the internet, the safe, child-proof version of the internet, is all we're going to get, unless, of course, and what we're seeing a lot of right now is an uptick in VPN usage. We're seeing all the top apps. This being virtual private networks, this being an app that you can download to your computer and you can mask where you're coming from, and then you can access whatever content you like. So I suppose it's not impossible to get around these restrictions for those who might have intent to do so. And this is something else that's been warned about. Hilariously, there was even some talk from Labour prior to the passage of the bill, some amendment trying to ban VPNs. I mean, no one has fully succeeded in banning VPNs. In China, they put a lot of work into trying to ban VPNs. But I suppose I don't know whether we really want to be in that category of a country. But that is the only kind of like, that's the next logical step in this, which is if you're going to say, well, British users can't access it, then you also have to say British users perhaps shouldn't be able to have access to VPNs, as that's kind of like a logical step to make. I don't know whether we're going to get there, but it does undermine the whole purpose of the Act, of course.
It does, and it highlights how surprising the formation of government policy can be when they clearly just haven't really put that much thought into this as a possibility, or they did and they thought, well, we'll just deal with it. And they have said this week that they're not going to ban VPNs, which is the right call, obviously. But it does, you're absolutely right, completely undermine their case, because it's so easy to download a free VPN that has its own dangers in its own way, but they could just sidestep all of these rules. So it's a sort of law and name
Yeah, the VPN issue is quite interesting. I mean, the first one, of course, is there are a lot of professional reasons to use VPNs. A lot of people listening to this podcast will, if they log into their work computer network from home, will need a VPN. And it's not obvious how you distinguish between those who are using VPNs for reasons of undermining the Online Safety Act and those who are using it for entirely legitimate work purposes. So I suppose that's the first element there. You could, I suppose, ban VPNs on the kind of professional VPN. It becomes a whole mess, and it's something the government clearly doesn't want to get into, and it's a bit of a cat and mouse game in the same way it is in China. You have to quite an extreme online censorship regime. Basically, the UK would have to buy a lot of hardware from China and force ISPs to use that hardware in order to operate this online censorship machine. That's basically what happens in a lot of authoritarian countries. Is they basically do take the China's firewall. Thankfully, we're not doing that.
Yeah.
But at the same time, as you are going to see increased VPN usages, there's a few implications here. One is that it actually is going to make it harder for law enforcement to go after genuine wrongdoers. If you're doing something wrong online, a lot of the time they can catch you through ISP records. Genuine criminal behavior here. That's going to be much harder now that you're kind of normalizing widespread usage of VPNs. So potentially, in terms of actually catching the true criminals, the people who are, let's say, spreading child sexual exploitation material, you potentially just going to find it much harder going down the line from here. At the same time, you've got this interesting fact here as well that if your British users using the internet kind of goes down, or at least it appears to go down, you're potentially just going to have platforms investing less into the UK or putting less effort into the UK because they just don't see the same traffic, and that it's just dispersed all over the world. And so more or less, you're making life a bit more inconvenient for people who do not use VPNs, who more or less, quote unquote, follow the law. You're making them risk their privacy by entering their ID, let's say, to visit an adult website or to have access to material that might be considered psychologically harmful to children. At the same time, you're probably not necessarily catching the worst wrongdoers who will just use VPNs. So you've ended up in a relatively unideal situation.
Bit of a lose-lose situation. So you predicted in 2019 and then in 2022 what would happen, and you, as you mentioned, we're only sort of halfway through the implementation of this act. So can you walk us through what's going to happen next? So we'll have you on in a couple of years to say, prove you right again.
Yeah. I mean, I was trying to look back at whether or not we had a record of the 2019 podcast. It seems to have disappeared, which in some ways is quite useful. I can say we told you so. I will say, of course, if you want to, as you referenced at the start, have a look at some of the issues we're talking about here, and see ways in which things have kind of operated more or less as expected. Our paper from June 2022 is still online. I suppose from here there's a few elements to this that are worth keeping in mind. The first one, which hasn't been talked about as much, which is even after we deal with this age estimation issue on a platform like X, there are still quite intense duties in terms of removing illegal content. And that's, in the first instance, that's of course right. You don't want platforms to be hosting illegal content. The issue, of course, is what do you consider to be illegal content? And the Act sets a quite extraordinary low threshold for removing illegal content. It's not, what might be considered any kind of normal legal standard, say beyond reasonable doubt or the balance of probabilities. It's this idea of what the platforms have, and I quote here, reasonable grounds to infer could be illegal. Now, I worry that sets quite a low threshold for expected removals. It is in some ways a census charter. If you want something to be removed from a platform, you make a claim that it's, let's say, a public order offence under Section 18 of the Public Order Act. That's basically the section that was used against Lucy Connolly, sent her to jail for 36 months over a racially aggrieved post on X. Now, of course, that was ultimately found to be illegal content. Lawyers will disagree. She had a day in court. She could defend herself. There were appeals, etc., etc. There's none of that process when it comes to asking a post to be removed from a digital platform. Instead, all the platform is expected to do is infer that it potentially could be illegal. They're somehow meant to also determine the poster's intent, in a kind of read their mind in a Minority Report type way. And if they fail effectively to remove enough content, they could also have quite extreme fines. Again, this is the potentially billions of pounds of fines, up to 10% of global revenues, not global profit, global revenues. So what I worry about here is that you can have this ongoing incentive to be extremely censorious in terms of what content you allow British users to see on their platforms. Now, the government will retort here. They'll say something like, "Oh no, there's also duties in the Act to protect free speech." For the first time, but those duties to protect free speech are very, very weak. They're like a duty to have regard to free speech. There's a duty to remove content, and there's a duty to have regard to free speech. And you tell me which one you think is going to end up trumping the other. So I think something we haven't quite seen yet is really those illegal content duties bite. And over time, I think that's that sort of concern. Combined in with those weak free speech sections. I think we're seeing some quite interesting stuff happen. Preston Bain, who of as an issue as well as a lawyer in the US, he's doing some interesting work around a lot of American platforms receiving notices from Ofcom, from the regulator, telling them to begin complying with the Act, even though in their opinion they don't fall in scope because they're not British platforms and they necessarily have big British user bases. Also letters from Ofcom, and there's some records have come out in recent days about what was going on in June last year around some of the riots and requests to remove content online from the riots. We're going to see a lot more over time, I think, of Ofcom trying to exercise its regulatory might over the platform to show, Ofcom has just been given hundreds of millions of pounds that they've employed, I think, probably hundreds, if not thousands of people whose job it now is to enforce this law. And they're going to want to do something. They're going to want to show that they're protecting people online as is their task. So I think we're going to see a lot of increased pressure from Ofcom. There's also the powers in there for Secretary of State. And this is a debate we had at the time about whether or not the Secretary of State should have expansive powers over the way this Act operates. To what extent should you have Ofcom? It's a supposedly independent regulator. I don't think there's such thing as independent regulator. I think regulators respond to political pressure. They respond to media pressure. But you can claim something there about Ofcom. Of course, Secretary of State is purely a political actor, and the Secretary of State has said compared anyone, in fact, Nigel Farage to Jimmy Savile, because you're basically a pedo if you have any issues with the Act, which is absurd, defamatory hyperbole. But you're going to have all these kind of ongoing political pressures and dynamics to keep an eye on here, because the Secretary of State does have powers to, I suppose, direct Ofcom's focus, to have lots of oversight powers when it comes to codes of conduct. And they get to set kind of what the priorities are for Ofcom. So we're going to have this ongoing dynamic of kind of media political pressure whenever anything happens on the internet. We already have at the moment, but now there's going to be like a mechanism for that to go through. There's even some sections, interesting sections in the Act where, in the case of this you can almost consider this a COVID section. In the case of some kind of public health or a national emergency, there's additional powers to Ofcom to direct tech companies when it comes to online content. So there's all these kind of provisions over time that could be used in quite concerning ways. At the time this was passed, of course, you remember it was a Conservative government. The Conservatives, when they were in power, particularly during the early Boris Johnson years, thought they were going to be in power forever, and that they would, of course, always be the ones to control this framework. I would say we tried to warn them that perhaps you're not always going to be government, and that perhaps sometimes the political winds change, as they now have. And the Tories at least claimed to be, free speech warriors. I don't think they were in practice, but they claim to be. I don't think Labour has any pretense to have particularly strong concerns about free speech. And they're not going to, and Ofcom under a Labour government is going to respond to that political incentive and therefore going to be way more aggressive in the way they're doing it. To keep going on, more things coming down the line. I also think it's quite important to keep an eye on private messaging. This has always been a big issue, particularly for the Home Office. They are concerned about the ways in which illicit activity goes on in private messaging. They're obviously right. There is, if you're an illegal actor, you're probably not posting things publicly on social media, but you might be using WhatsApp, you might be using Signal or Telegram, whatever else it may be. These are end-to-end encrypted platforms for the safety and security of users. There are powers within this Act that allow Ofcom to direct these companies to basically install kind of tracking software about the messages you send, particularly when it comes to trying to prevent child exploitation material. Now, that is a completely, genuine good goal to try to stop the spreading of that material. At the same time, though, if you're directing software to be installed on our devices to track what messages we send, then we no longer have private communications, we no longer have encryption, and all our safety is threatened. Now, that is a dormant provision within the Act, but that is there and something that could be used in future. WhatsApp, among other messaging firm companies, have said that they would pull out of the UK market if forced to scan their user messages because they have a commitment to their users and to their privacy and to their encryption. So I think that's another sleeper issue to keep an eye on as well.
So plenty more coming down the tracks and plenty more to be pessimistic about. If you were Peter Kyle, if you were in that chair, would you just completely repeal the act, or would there be certain specific tweaks you'd make? What would be your approach?
Yeah, I mean, I look, I opposed the passage of the act in the first place. I think the logical conclusion here is that we should repeal the act. And I think there are also some other sections of the act that are actually being used quite a lot in terms of criminal sanctions exist on the act. You've seen quite extensive uses, in fact, under the Land Safety Act of these criminal provisions. I think maybe if you are going to have criminal provisions, I would almost tighten up the definitions under those. If you wanted to take a more moderate approach rather than abolishing the act, I think that reasonably likely to infer standard threshold is quite concerning. I would have much stronger requirements on Ofcom to consider free speech in terms of the way it's exercising its duties. There's some vague requirements in there. You could say under human rights law for Ofcom to consider free speech, but I don't think it's front of mind. But there's something quite fundamentally wrong with this act and the way it is structured. And this does actually go back to April 2019 when we first sat down to discuss this on the podcast, which is this so-called duty of care model that is created under the act. And this actually came from, I think it was the Carnegie Trust, for whatever reason, decided this was their issue and this was their model, and were ultimately quite successful in getting government to adopt it. And this effectively treats the digital world as the same as physical world. It treats speech as the same as physical danger. So traditionally you might have a duty of care. Let's say we go to a manufacturer of this chair, we buy this chair, and I sit down on it, and it breaks, and I hurt myself as a result. And then I go, you could say in a tort, they have a duty under the law to provide me with a safe chair. And they have not done so, and therefore they owe me some sort of compensation. That's usually, the duty of care is between me and somebody who's caused me some kind of harm and the expectation otherwise. And usually, again, it relates to some kind of physical harm. Applying that kind of duty of care model to speech has never been a good idea, because it assumes that I have, as a platform, some kind of duty to my users to protect them from the speech of other users. And so it's like an intermediary who's not actually responsible themselves for it. Let's remember this, the harms that are caused online are harms caused by individuals who post material that might be illegal or share content that might be illegal. Some of those harms are entirely legal harms, by the way. I don't think psychological, and this is nothing you could do to modify the act to make it a bit better. I don't think a psychological harm is a justifiable basis on which to censor speech online, even for children. I think maybe parents could make a decision that they don't want their children to see things online, but I don't think the government should be involved in regulating psychological harm. I think that's too much of a slippery concept. Hurt feelings is not something that justifies government intervention. But when you start applying that whole structure, whole model to speech, you're basically just asking for a model of censorship, because the only way to protect users is to stop them being able to post things. And therefore, at its core, the act is not something that is conducive to a free and an open liberal society. And ISP Reform has committed to abolishing the act. I don't know how they're going to square that in the end, because obviously there are a lot of demands and expectations to protect children. At the same time, the Conservatives also have a particularly strong case to make here, because they're the ones that introduced the act in the first place. Labour's obviously not going to do much about it, because they always support the act. In fact, they said the act didn't go far enough. They're the ones who said that we should have legal but harmful within the act. They're the ones who said we should be considering bans on something like VPN, at least at the time of the passage of the bill, if not today. So yeah, I think that there's something quite fundamentally wrong with this legislation that needs to be addressed. That if a few amendments around the side could definitely improve things, but unless you're willing to take a more extreme step, then I don't think you're necessarily going to grasp the issue when it comes to free speech and privacy.
Absolutely. Well, thank you very much for joining us, and thank you for listening. As Matthew said, that briefing paper from 2022 all about this is still on the IEA website. Thank you for joining us, and we will see you next time.